Welcome to Division 2 of the Colorado Court of Appeals. Your panel today includes Judge Grove, Judge Sullivan, and I am Terry Fox. And we will begin our afternoon docket with Freed versus Bonfire Entertainment, 23 CA 965. I see that counsel are present. I'll just briefly remind counsel that our arguments are live streamed. So if you have confidential information, take care to protect that. And for everybody, not just counsel, if you could silence any electronic devices that you have, they tend to interfere with our recording. You each will have 15 minutes to argue. The appellant may reserve some of that time for rebuttal, but you'll have to keep track of that. If counsel are ready, the court is happy to hear from you.
May it please the court, my name is Greg Urich of the law firm of Miller and Steyert, and we represent the appellants, of course. Our clients are 11 residents of Chaffee County, Colorado, who live near or around Buena Vista, a small town of about 3,000 people. And as of the filing of this case in July of 22, almost 2 years ago, 6 out of the previous 7 years, the Board of County Commissioners of Chaffee County had approved special use permits to hold large concert events on a property called the Meadows, which is the area in which my clients live, near the Meadows. The Meadows it looks like farmland, but it's zoned residential, and it is owned by a for-profit corporation out of Arizona. And these concerts draw 5,000 to 10,000 folks each time. On one occasion, the limit was 25,000, although not that many attended. And it's particularly disruptive to the entire community of 3,000 people, but also my clients who live nearby and are subjected to the noise from a basically 2-week exercise, a week to set up, 2 days of the concert, another week afterwards, with bright lights shining in their windows from the night crews working on setup and teardown. This case is, of course, about the application of the Colorado noise abatement statute to those circumstances. It's important, I think, that the statute is captioned in the statute books, noise abatement. That's what it's about. And the permits for these particular concerts have allowed noise levels typically of 105 decibels. On one occasion as high as 122 decibels. And those are in severe violation of the limits in the statute. The noise abatement statute declares that excess noise is a matter of statewide concern. And the noise should be measured 25 feet from the lot line, which is 25 feet from the Meadows. The legislature tells us, after giving us some impenetrable definitions of decibels, that a 3 decibel increase is a 100% increase in noise level, and a 10 decibel increase is 100% increase. I'm sorry, 1,000% increase in noise level. And so 105 decibels as compared with the limit at night of 50 is a 55 decibel increase, which is thousands of times louder than the limits. And what we're really talking about is the difference between a quiet neighborhood, which is what this normally is, and attending a Red Rocks concert.
Counsel, before you get too far into the act and the language of the act, could you just briefly address the 28-day deadline in Rule 106?
Sure.
As it pertains specifically, I'm interested in, as it pertains to your claim against the county. I understand the defendant promoters are not government actors, so there's a question whether that deadline could apply to them. But as it pertains to the county itself, Can you speak to the 28-day deadline?
Happily, Your Honor. Rule 106A4 simply has no application to the circumstance. These were quasi-judicial decisions. We don't dispute that. But there must be an absence of an adequate remedy. It's in the conjunctive. And so it has to be a quasi-judicial decision where there is no plain, speedy, and adequate remedy provided by law. Well, this statute provides exactly a plain, speedy, and adequate remedy at law by providing an injunctive relief proceeding for anyone who is affected by it, and specifically providing that it's a public nuisance to exceed these limits.
Counsel, what do you make of, I think it's the promoter defendants in their supplemental briefing footnote 1, they attempt to distinguish or differentiate the Hobbs case from this case, arguing that you never argued that the state statute preempted the zoning provisions that were applied here.
Well, that's a new argument for them to claim that, but the fact is that there is a preemption provision in the noise abatement statute, and no one ever claimed that the county could exceed these requirements without complying with the statute. So in the trial court, we never got the argument that this is preempted somehow, and that the Board of County Commissioners can adopt whatever they want and have those prevail. The statute, as a matter of statewide concern, says noise is pollution, essentially. And the fact that the statute sets statewide standards for everyone, I think, answers that question. I think this is a matter of statewide concern as defined by the legislature. So the statute was adopted in 1971, and it hasn't been amended often. But in 1986, at the behest of a couple of legislatures whose districts included Fiddler's Green, a proposal was made that was referred to by some as the Fiddler's Green exemption. And basically, there was no exemption in the statute that said that there could be public concerts. And so the concern of Fiddler's Green and the legislators was that a Willie Nelson concert at the Pueblo County Fair could be enjoined by neighbors for exceeding those limits. Or a concert in Wash Park put on by the city and county of Denver with the Denver Symphony, because there truly was no exemption. So they proposed an exemption that applies to 3 categories of users: the state, political subdivisions, and not-for-profits, as well as their lessees, licensees, and permittees. And so if reading the statute, this article is not applicable to the use of property. The use of property by this state, any political subdivision of the state, or a not-for-profit. Those entities have to use the property. That has never been the case in this lawsuit or in the Hobbs case as well. Those entities never used the property.
Is your position that the statute is not ambiguous and that we should interpret the plain language in your favor, or is it ambiguous and we should look to legislative history?
Well, I think, as in the case of most lawyers making an argument like this, both. I mean, on the one hand, we think use of property is clear and unambiguous, at least applied here.
Okay, let me push back on your argument about the plain language. My concern is that you say, okay, this article is not applicable to the use of property by the state, any political subdivision, or any other entity not organized for profit, ... or any of their licensees, lessees, or permittees. So why isn't that? It seems to me that what the district court found here was, okay, this is a political subdivision, and the concert promoter is a licensee or permittee of the political subdivision. So where does the political subdivision having to use the property factor into that finding? It seems that that's what your focus is here. So if you could clear that up for me, it would help.
Sure, the city and county of Denver can hold a concert as it has in City Park with the Denver Symphony performing. That previously would not have been exempt. It is under this statute. Now, what the district court did and what the appellate court did in Hobbs were to ignore the language use. And the reality is none of these parties have explained how do you give meaning to the phrase use the property. The Board of County Commissioners in their brief, I just noted this was at page 11, they basically say, well, there was no discussion in the legislative history and therefore it doesn't mean anything. And I have searched the briefs of the promoter defendants in vain to find any explanation as to what that phrase means. Clearly from the legislative history, it means that the entity that is exempt, which is the state, the political subdivision, or the nonprofit, is the entity that has to use the property either on its own or through its licensees, lessees, and I've lost the third one, permittees. And that's the only way you give meaning to that language. As for whether there's a reason to look at legislative history, I think lawyers sometimes get tied up on the various kinds of interpretive tools we are given, and they say, well, if it's clear and unambiguous, you don't look at anything else. Well, we think use of property is clear and unambiguous, but we're in litigation about what it means. And so surely you look at the legislative history to divine what the legislature had in mind. It's pretty simple. All of the tools are directed to figuring out what the legislature had in mind. Yes, Your Honor.
So when you say your interpretation of use of property is use of its property, that is, the political subdivision, nonprofit entity, or the state has to be using its property?
No, that's where I think the Hobbs court got it wrong, because Hobbs never argued, and we don't argue, that the entity that is exempt, the state, the political subdivision, or the nonprofit, has to own the property. They can lease the property. That's how lessee has meaning here. They can lease a concert hall or an open air venue somewhere. They can certainly do that. They just have to be the user of the property for the event. And in this case, the Board of County Commissioners, as the political subdivision, is not using the property in any sense. And so how can they satisfy that language of the statute? And if in fact the intent of the legislature was to exempt political subdivisions anytime they decided that a concert could be held in a particular venue, you've just created a local control situation under a statute that is fundamentally a statute dealing with statewide standards. That's what it says. And you've just delegated to every Board of County Commissioners, every city, the power to decide when this statute will be ignored. That couldn't have been the intent. And the additional anomaly that results from the arguments of the defendants is that there was no point in starting out a process of amending this to deal with Fiddler's Green as a nonprofit, which is the title of the bill, if in fact you're going to let every political subdivision do their own thing, because most of the time the political subdivisions have the final say on whether it happens. They grant the special use permit that the Board of County Commissioners granted. If there are no immediate questions, I'd like to reserve a little time for my rebuttal.
You may do so, and you just have short of 2 minutes.
Thank you.
And the court is ready to hear from the appellees.
May it please the court, fellow counsel, I am Leslie Schluter, and I am here representing the Chaffee County Board of County Commissioners. I have found it challenging to follow the argument of the, on behalf of the appellants. The case is actually fairly simple, and it was, I think, appropriately, cogently put together by the district court in its order granting the motions to dismiss. The county's position begins with the point that the plaintiff's claims are subject to 106, and not having proceeded under 106, they are jurisdictionally precluded. So ultimately, the decision by the district court was that it lacks subject matter jurisdiction over the plaintiff's claims here.
Do you
Counsel-
take a position on the plaintiff's claims vis-a-vis the private defendants? Or is your argument under 106 limited to your clients?
It's limited to the Board of County Commissioners.
All right.
And counsel, I understand the 106 argument, and I certainly agree that, specific elements of the 2022 permit or the 2021 or earlier permits were not properly before the trial court and are not properly before us. But it seems to me that the neighbors' challenge is broader. I mean, they are challenging how the board interpreted a state statute, and isn't that pretty much the bread and butter of what courts do? Especially this court. I mean, we engage in statutory interpretation every week.
There is controlling case law from the Supreme Court cited by the district court in its decision referring to Danielson, which relied on tri-state transmission versus the city of Thornton, that a party is not allowed to present a declaratory judgment in basically an action for injunctive relief and declaratory judgment, which is precluded to it under 106.
But isn't that exactly what happened in the Hobbs decision? I mean, they were seeking injunctive and declaratory relief. Like, what does this statute mean?
In the Hobbs case, 106 was not at issue because the challenge was to an ordinance, and when the challenge is to the ordinance, then a Rule 56 or a declaratory judgment action could be pursued. But the plaintiffs are not challenging an ordinance here. They're not challenging the noise abatement statute. They are basically trying to do through a different means what is precluded to them under 106. If there are future, in the event of future applications for special event permits, their remedy, as the district court pointed out, is to attend public hearings and participate in the elective process. There is an adequate remedy to these such decisions through 106. A record would be developed. It would be presented to the district court for review. I hope I answered your question. So it's Danielson and Tri-State from the Colorado Supreme Court that would say you cannot do through declaratory judgment what is precluded by failing to go through 106, or which is covered, a corollary of which would be which is covered by 106.
Is there a evading review problem here? I mean, it seems like for the district court and then any appellate court to kind of review the decision here, there just wouldn't be time. I mean, the county's decision on the permit was in May, and then the concert's in September. Is that timing right?
Well, the timing issue is that under 106, this is a special permit. This is a special permit procedure, which is quasi-judicial. When the final decision is made, someone challenging that in a aggrieved party would have the right within 28 days to appeal to the district court, which can be done, and the record would have been developed and then presented to the district court for review, where the plaintiffs would have the opportunity to make their arguments, but in the proceeding before the county commission, and it would be in the record before the district court. So it doesn't evade review. It's just that the plaintiffs are trying to circumvent that.
I'm sorry, go ahead.
Well, do I have the timing right, though, with the county's permitting decision was in May and the concert's in September? Is that timing correct?
Yes, I do believe that is correct.
So how could this court review, I mean, that's 3 or 4 months. How could this court have the opportunity to review, let's say the district court was able to issue its decision in that 4-month period. How could this court have the opportunity to review that, given the timing?
If the district court were to agree with the plaintiff that the concert should not go forward, then the permit would not, then it would be rescinded. It would not be able to go forward. If the district court determined that the 106 standards were not met and declined to and denied the appeal, then the plaintiffs could, I assume, ask for some form of remedy from the district court in order to present this to the Court of Appeals.
Some sort of stay or
Right,
injunction? Okay.
right, but the plaintiffs have not done that. The record could be fully developed before the Board of County Commissioners, and there would be a full record to review at the district court within the 28-day, under a filing within 28 days. So it's not as if it would evade review. It hasn't been attempted in that way. And in this case, the plaintiffs are not challenging the land use code. They are not challenging the state noise abatement statute, which has an exemption in 11 for what has happened here. So it's not an evasion of review problem, I don't think.
I have one more question about Rule 106.
Okay.
And that is, I'm looking at the rule now, and I'm just curious as to your interpretation of 106A4 Roman numeral 5, which says, the proceedings before or decision of the body or officer may be stayed pursuant to Rule 65 of the Colorado Rules of Civil Procedure. I read that as saying that they could seek an injunction as part of the Rule 106 complaint. Is that a fair reading, or do you disagree with that?
I agree with that,
Okay. All right.
yeah. I would like to reserve the remaining time for my fellow counsel.
It's your time, so it's up to you.
All right. Unless there are further questions, I would like to thank the panel for considering this case and ask that the district court order of dismissal be affirmed. Thank you.
May I please the court? My name is Brian Malzahn. I represent Bonfire Entertainment, South Maine Arts and Parks Trust, and Meadows Farm. I wanted to echo what Ms. Schluter has provided by way of argument with respect to the questions you have asked him. I will not try to replow that ground. What I would like to do with the time I have is just address.
Before, can I
Sure.
plow it for you for just a second? I just want to make sure, is your position that the plaintiff's complaints against your clients are barred by 106?
It is.
Okay. Can you explain why,
Sure.
given that your clients are not government entities?
Sure. The cases we rely upon, if you'll give me a moment, Your Honor, for that proposition are, and so the claims that you're addressing are nuisance, statutory nuisance, common law nuisance, and then conspiracy. All of those claims ultimately rest upon a determination of whether or not the decision by the Board of County Commissioners was correct, whether or not they abused their discretion or not. They are not, and we are also a part of the declaratory judgment action as well. And there's a case, JR1 LLC, it's at 160 P3rd 365, and it states, another division of this court stated, and I quote, all claims that effectively seek such review, whether framed as claims under CRCP 106A4 or not, are subject to Rule 106. We interpret all to mean all. And I would also point your honors to two other cases, Van Wyck, which we cite in our briefs, as well as Middlecamp, both of which stand for the proposition that there can't be a nuisance if what was done didn't exceed the bounds that a governmental agency or the law allowed.
It seems to me that might be a defense. I don't see why that would bar their suit from proceeding. I mean, those are two separate questions, right? One's a jurisdictional question, and the other is whether you have, I mean, the defense would be, we have a viable permit here, and you go and show that to the court, the court says, okay, well, I mean, I guess there wasn't a noise violation here. But that seemed to me to be a different question than, did the court have jurisdiction to hear the complaint against your client?
I guess I interpret it, I read 106 as saying, when the gist of the claim is that a government agency exceeded or abused its discretion, it applies. And when I look at JR 1, the case I just referenced, and it says all claims, I believe we fit into that category.
Okay.
So I read JJR one. I didn't see that it involved I could be wrong, but I didn't see that it involved a purely private defendant where the rule you articulated was being applied. Do you have a case where a purely private defendant, like your clients, took advantage of the 28-day deadline in Rule 106?
I believe I did. It is my recollection that there was a defendant that, I can't remember the name of it, I apologize, but I think it did. There are, I think, 3 or 4 district court cases that do dismiss claims against non-governmental defendants on the basis that they were untimely.
And those cases involve an indispensable party analysis, right?
Ultimately, they probably do, yes.
But that isn't what happened at the district court level here. There was no finding or holding by the district court that your clients were indispensable parties. Am I right?
I do not believe that came up, but I would not understand how they could not be. The other points I'd like to make in the time that remains, and these have to do with, I guess, my opportunity to respond to some of the contentions that are in the reply brief. There is a contention by appellants that the Board of Commissioners' prior decisions, quasi-judicial decisions with respect to the prior festivals are irrelevant. And they disagree with that on the basis that they are arguing a pattern of misinterpretation as an exception to Rule 106. And our response to that is that that objection can't be true, because if it is, then that exception would swallow the rule. The other point I would make with respect to that is that with respect to each and every one of those prior decisions, each was also subject to review under Rule 106. And that opportunity was never actually taken by the appellants. The other question I would like to address, and it is one that was asked a little bit earlier, has to do with whether or not 106 applies. Is my understanding that the appellants say it doesn't because they never alleged, they do not argue, that the Board of County Commissioners exceeded or abused their discretion. Rather, they say they're arguing or alleging that they misinterpreted the statute. That is an argument that is ultimately a detour into semantics, based upon a misunderstanding of the law. The law says that seeking relief based upon an erroneous interpretation, a misconstruction, a misapplication of the noise abatement statute, which this complaint clearly does allege, is the same as seeking relief based upon an allegation that the Board of County Commissioners abused its discretion. And the cases I would cite for that are DeLong, 25P3rd 1194, Gallegos, 155P3rd 405, and Greyhound Racing, 41 Colorado App 319. I think, if you just give me a second, the other thing I wanted to mention, and this has to do with the exception that appellants are relying upon with respect to a plain, speedy, and adequate remedy at law. That particular exception, as I understand it, has been found or applied by courts where the plaintiff has been denied due process. For instance, when the plaintiff was not given prior notice of a hearing in which a quasi-judicial decision was rendered. In those instances, the courts have said, yes, Rule 106 does not provide you with that remedy. That didn't happen here. In fact, the opposite did. Appellants were consistent and continuous attendees, vocal participants in the process. I have 30 seconds left. If any of your honors have any questions, I'd be happy to answer them. Thank you.
Mr. Urick, you have a minute and 41.
1 minute.
A minute and 41 seconds.
Thank you. We still haven't heard an explanation for what the phrase use of property means. I mean, a principal interpretive tool is to give meaning to all words. That's a phrase that stands out. Use of property by, and they don't tell us how the Board of County Commissioners used the property. They simply let Bonfire do it. Second point, under Rule 106, as I mentioned, it's in the conjunctive. Quasi-judicial decision that's being reviewed, and there is no plain, speedy, and adequate remedy provided by law. Not provided under this rule, provided by law. And provided by law is so much broader than a Rule 106 proceeding. So it can't be limited to simply due process issues in the 106 proceeding. We have an adequate remedy provided by the very statute that our statutory nuisance claim is under, and that is injunctive relief.
I want to circle back to the merits question really quickly. And this is, I'm hoping you can help me understand this. I know that they didn't address use of property, but I'm going to do some ellipses here. But why isn't the answer to your question? This article is not applicable to the use of property by ... any political subdivision of this state ... or any of their lessees, licensees, or permittees. Why doesn't lessees, licensees, or permittees relate back to the use of property that we're talking about? It seems to me that there's an argument to be made that the political subdivision is just a conduit for letting the licensee, permittee, or lessee to hold the event.
They didn't need the or. I mean, well, let me rephrase that. The simple fact is that there refers back to the three entities that we're talking about that have an opportunity to be exempt: the state, the political subdivision, the nonprofit. And so, or there means a lessee of the county or a lessee of the nonprofit can participate in putting on a concert, but there still has to be use by the county, by the nonprofit.
Okay.
May I make one quick point or not?
Just a concluding remark.
Okay. The Mount Crested Butte case says only claims effectively seeking review of a quasi-judicial decision are dismissed. These nuisance claims are not effectively seeking review of a quasi-judicial decision. Thank you.
Thank you both. Thank you to all counsel that argued today. We really appreciate the information you provided with us. It will be very helpful to us as we deliberate on this case. With that, your case is concluded, and when counsel for Freed have vacated the desk, counsel for People v. Taylor are welcome to come up and set up for their argument. People v. Taylor, 22CA515. Just brief reminders that our arguments are live streamed, so take care with any confidential information that you might have. And for anybody that has newly arrived and entered the courtroom, if you could silence any electronic devices that you have, the court would very much appreciate it. You each have 15 minutes to argue your case. Appellant may reserve part of your time if you wish. If counsel are ready, the court is ready to hear from you.
Thank you, judges. May it please the court, I'm Joseph Goodner, 41941 for Charles Taylor. The jurors were on to something in this case when they asked if Mr. Taylor had a crime partner who could have committed this burglary using his mask and car. That's exactly what they could have thought that his alternate suspect evidence showed. But an error in gatekeeping kept this key evidence from the jury. To start, Mr. Taylor wasn't allowed to testify that he was an eyewitness who watched his former crime partner commit this burglary in front of him after being driven there and refusing to participate. The gatekeeper doesn't weigh credibility, and it doesn't view a defendant's testimony more skeptically than a third-party witness. It simply asks whether the proffered testimony would meet the relevant legal standards should the jury choose to believe that testimony. The relevant legal standard only requires something more than motive or opportunity. And this identified the alternate suspect committing the charged act of burglary itself, which is a far more direct link that should have gone to the jury, subject, of course, to cross-examination, which my client was prepared to face. Although it's not necessary for admissibility, my client's eyewitness testimony of another suspect was highly corroborated by a number of other proffers. In a recorded jail telephone call, the alternate suspect asked if his fingerprints were wiped off the vehicle used in the burglary, which connects him to an instrumentality of the charged crimes and demonstrates his consciousness of guilt through an attempt to destroy the fingerprints linking him to this crime. There were two witnesses who heard the alternate suspect confess, and one of them even heard the detail of an unwilling second person who refused to participate, which is precisely what my client wanted to testify to. On top of that, the guy who rented the car we wanted to call him to testify that the alternate suspect had possession of the car on the date of the burglary, and that my client only received the keys some 11 days later. And the alternate suspect also sent text messages that unfortunately weren't disclosed, but they were referenced before the trial started, where he talked about doing reconnaissance on this victim at his warehouse for a burglary.
Counsel, can you, educate us about what I see as a conflict? I mean, Mr. Taylor couldn't testify, I saw him commit the burglary, while at the same time testifying that he was nowhere near where the burglary happened. Instead, he was in, I don't know, what's Black Hawk,
yeah.
selling, I guess at the time they were probably legal substances.
Right. Well, the alibi was kind of an impossible situation that he got forced into after his chosen defense of alternate suspect was excluded. So, he comes, he wants to testify to alternate suspect. He makes the offers of proof prior to trial. And prior to trial, the court's telling him, hey, your own testimony is different. I'm excluding all this other evidence. I think those witnesses are hearsay. We think they're statements against interest, but the court was telling him, look, it's different if you take the stand and say whatever you want. Then he gets the Curtis advisement, and the court extends the alternate suspect order to his own testimony. So he's come to this trial thinking he's going to be able to at least support his defense with his own testimony about being an eyewitness, which is something that's absolutely for the jury to review. And that surprise gets excluded. And so he's kind of in this no-win situation where general denial is a loser in almost every case. And so he's trying not to run a general denial. He does what he has to do, and he pivots to another defense that's not a general denial. And that's improperly excluded too, and then that got improperly held against him by not correcting the jury question. But I think the alibi was because he was really forced into an impossible position when his chosen defense, alternate suspect, was excluded by the court. And there was really good reason for the jury to credit this alternate suspect defense. They asked 7 questions about it, including, do you know who committed the burglary? Did you have a partner that also committed burglaries that could have used your car and mask to commit this burglary? And the reason the jury had these questions is because the government had a weak case. Their victim saw the burglar twice, not wearing a mask, and couldn't identify my client as the person he saw. At trial, the victim testified that the burglar was 6 foot, 190 pounds. And the jury's looking over at defense table, and my client is 5'10", 235 pounds. He's not a tall, skinny guy like the victim described. He's a short, tanky guy. I mean, 6 foot, 190, 5'10", 235. They're really not in the same ballpark. And then the government's DNA evidence was a mixture. And even if you assume that Mr. Taylor was the major profile on that DNA mixture, the evidence was that the burglar only carried the mask. I think that's something the government even conceded in opening. The burglar only carried the mask, and the government's own DNA expert admitted that if you're only carrying the mask, you're only leaving touch DNA behind. That's consistent with being the minor profile, not the major profile, which is all consistent with what Mr. Taylor wanted to testify to, namely, my former crime partner, we were riding around in this car. He drove me to this thing. He said, let's do this burglary together. I said, no way. He took my mask from the car, and he went and committed the burglary without me. I watched him. And if there's any questions about his credibility, that was a function for the jury. That was not something to be excluded on gatekeeping. And when we have such a weak case of guilt, we have all these unanswered questions about identity. Even the jury, the questions the jury was asking went straight to the same topic that the excluded evidence would have talked about as well, which showed they were interested in this theory and likely would have accepted it had my client had an opportunity to develop it as he should.
Can we talk alibi?
Yes, please.
I'd like you to delve into a bit the difference between Hampton 2 and Hampton 1 and the prosecutor's argument that I'm not sure the AG is actually defending on appeal, but I'll ask that in a minute, that basically the Hampton 2 factors can be applied to a defendant's own testimony regarding his alibi that is outlined in Hampton 1. I take it you disagree with that. If you could maybe explain why Hampton 2 doesn't affect the statement in Hampton 1 about how a defendant can testify to his own alibi.
Yeah. Well, Hampton 2 was specifically a case that involved third-party alibi witnesses. It wasn't the defendant as an alibi witness. Now, the reason that they reached the question was because Hampton 1 was a facial challenge to the statute. So to address, whether it's facially constitutional, they address the question of, is there a safety valve for a defendant's own testimony so we don't violate it? And that makes sense if you think about when we give the Curtis advisement. We give it after the government's given its case because a defendant can't rightly decide whether he's going to choose to testify or not until he's heard the government's case, and that's why we do the Curtis when we do. But no, I don't believe that Hampton 2 changed Hampton 1's conclusion in any way, and I do believe that's been conceded. It's slightly equivocal wording, but I think it's effectively a concession. And our position is that Hampton 2, the factors, are factors that you would apply in the event of an undisclosed third-party alibi witness. The reason you'd apply those factors is because excluding a defense witness is such a severe sanction.
Well, that leads me to my next question, and that is, again, the AG is a bit equivocal on this, but can you talk about why your position is that this is constitutional harmless error review? And as I said, I'm not exactly sure if the AG's position is whether it should just be considered trial error, that is non-constitutional harmless error, or constitutional harmless error. Can you explain why you think we should review for constitutional harmless error?
Absolutely. I believe the issue is preserved, among other things, under my client's constitutional right to testify in his own defense. And the ability to provide alibi testimony is a critical component of his right to testify.
Why wasn't it? I mean, so the constitutional harmless error generally means that he was basically prevented from putting on a defense. There are nuances that I'm steamrolling there, I admit. Why wasn't it enough that he was able to get up on the stand and said, I wasn't there? I can't say where I was because the judge said I couldn't, but I wasn't there. Why isn't that enough to convert this into trial error, given that he was able to say something?
Sure. Well, first, it wasn't enough for the jury, and we know it wasn't enough for the jury because they asked 4 questions about it. Now, one of the questions the jury asked was, hey, do you have any video? And without disclosing alibi, he wouldn't have been able to bring in any video. That's true. But the other 3 questions, there were 3 questions from the jury that specifically asked him to testify to more details about his alibi. Where were you? What were you doing? And he wasn't allowed to provide any of that. And I think if we put the shoe on the other foot and we were to say, hey, let's say we are here on a case where the defendant wanted to stipulate to the nature of his convictions, and he didn't want all the factual basis of something to come in. I think what we hear a lot of times is, hey, we get to prove the case however we want in the manner we see fit, because narrative richness and integrity is very important, to providing a cohesive narrative that the jury can sink their teeth into. And I think we see that, the jury was effectively punishing him for not being able to do that in the third issue. But as to being completely prevented from being able to present a defense, I mean, in some sense, it depends on how you define a defense, but he comes to trial ready to testify that he was an eyewitness. That's not a general denial, that's a specific defense, and he's excluded from doing that. And then he tries to pivot to alibi. Like I say, he got put in that impossible position. And then that's excluded as well, and he's only able to give this vague detail of, hey, I have an alibi. Well, I have an alibi, and here's what my alibi is. I was here, I was doing this. Those are 2 completely different things. And so when you look at the errors together, I believe that he was completely prevented from presenting a defense. He was relegated to a general denial in a case where the government had, we can call it weak, we can call it not a great case, but it's not a great case when they can't identify anybody. They describe this wildly different body type. Their DNA isn't very solid. It suggests another person according to their own expert. And then he gets pushed into this general denial when he's got 2 prior defenses that he tried to run.
Is your position that the denial of the alibi defense under Hampton 1 is independently reversible, or does that depend on the fact that he had to pivot to it from after having the alternate suspect defense rejected?
I believe you analyze them independently. I mean, I think, and I understand it might create some heartburn that his first defense was, hey, I was there and I was an eyewitness, and then that gets erroneously excluded, and then his next position is, well, I wasn't there at all. But I mean, the reality is a defendant has an opportunity to testify in his own defense, and that was a position he never would have been in but for the first. But no, I think independently they are reversible.
Mr. Goodner,
Yeah.
if we agree with you that there was reversible error on the alibi issue, again, hypothetically, do you have a position on whether we need to reach any of the other contentions in your brief, particularly since you are saying that the alternate suspect was sort of the primary defense?
If you find that the alibi issue is independently reversible, I do not believe that you'd need to reach any of the other. I mean, the notion that these issues would come up in the exact same way in a retrial is, I suppose it could happen, but I think it seems unlikely on a number of these issues that they would go this way.
And then related to the standard of review question that you got from Judge Grove, I mean, do you have a position if we choose to apply the non-constitutional harmless error standard, kind of the trial error standard, whether or not reversal is mandated under that sort of easier standard of review?
Sure. Yeah, I believe that reversal would be warranted either way. The position that I recall from the answer brief is that because alibi wasn't disclosed, Mr. Taylor would only be limited to his own testimony, and therefore he wouldn't be able to provide any support for his alibi, and therefore the government's position it would be harmless. And what I would say to that is I think it's kind of a mantra of prosecutors that testimony is evidence. And the testimony of a defendant is not viewed any differently than the testimony of a third party. They talked about that a lot in Vander Poye with the elimination of the direct interest doctrine. It's for the jury to make credibility determinations, not the gatekeeper. So I would say, yes, under a non-constitutional standard or reversal, it would still be a reversal because the jury's asked 3 questions saying, hey, we need to know more about your alibi. Where were you? What were you doing? And those were things, the 4th question, the video, he couldn't have introduced the video, but the 3 questions that they did ask went straight to his own testimony. His testimony is evidence. The jury could have viewed it as support. And even if you don't decide the first issue, still take a look at the jury questions they were asking on alt suspect 2, because they asked 7 questions about alt suspect and then they asked 4 questions about alibi. And the government has these holes in the identity case that they have, and the jury's really looking for anything because I think that they're smelling that something doesn't quite fit here. And so, yes, I think that would pass muster under any standard of reversal. If there's no further questions, I would like to reserve my time for rebuttal.
You may do so. You have 5 minutes.
Thank you.
May it please the court, my name is Jacob Lofgren, registration number 40904, and I represent the people in this matter. I want to begin with the alternate suspect issue, as that's where opposing counsel began, and I want to begin with the question Judge Fox pointedly asked, and I think is directly and most relevant here. The defenses the defendant wanted to run were completely inconsistent. And what he is trying to argue here today is that because he was not able to run the first defense he wanted to run, he should have been permitted to make up a new defense, completely wholesale, without any support.
Why isn't that a jury question? I mean, let's assume that the alternate suspect, it doesn't matter actually whether it was, for the purpose of this question, it doesn't matter whether it was appropriately excluded or not. He has a right to testify in his own defense. And if he wants to say, I wasn't there because I was selling marijuana in Black Hawk, and the jury then gets to decide whether to believe him, right? So I guess I understand that sitting here, it is a little bit confusing that he's giving 2 different stories. That raises a host of other issues that I don't think we need to address. I guess my question is, why does that matter? The jury gets to decide based on the evidence that they're given, which is his testimony subject to cross-examination, whether to believe him when he says that.
I think it matters to the court's gatekeeping function, which is exactly what Elmar talks about. The court has to act as a gatekeeper in determining whether there is actually evidence of an alternate suspect. And in this case, when we look at these 2 issues together, the confusion created by the conflicting defenses undercuts the assertion of either of these defenses.
Was the court aware that he was going to assert an alibi defense when it rejected the alternate suspect defense?
I would say that's a little bit of a mixed bag here. And I think that gets to the first point I wanted to make on the alternate suspect, which is the timing of how all this played out lends itself to the confusion that happened here. The alternate suspect, as it was first endorsed and argued by the public defender when they were still representing Mr. Taylor, simply relied on 2 facts. CJB looks a lot like me, and he was charged with me in other offenses. That is the record the court had at the time it was ruling on the alternate suspect defense. That was approximately, I think, 4 to 5 weeks before trial. That defense becomes more muddled after Mr. Taylor fires his public defender on the eve of trial, I think about a week to 10 days before trial, and starts saying, but I have all of these other witnesses, and I could testify that I saw him do this. The court was left kind of in the situation that Dye warns against, which is deciding on all these things as trial approached and during trial. Because a lot more of this evidence, a lot more of this allegation of witnesses that can support this alternate suspect defense is thrown at the court in the middle of trial, as trial is happening. I have this other witness. I have this other witness. Someone can say that they knew CJB had the car, except that as we're listing all of these witnesses off in the course of trial and at pretrial readiness, we're not providing contact information. When the prosecution tries to contact one witness in the course of trial, that witness says, I have no idea what you're talking about. This man has never reached out to me. I'm not involved in this case. I've never been subpoenaed. Everything that was happening as this was playing out through the course of the trial undercut the fact that there was any support for this alternate suspect defense. I saw some hesitation. I thought maybe there's a question coming. So So the timing, I think, is the big concern here to start with. The second being the inconsistent defenses. The third is that we require a non-speculative connection if we're going to allow an alternate suspect defense in any event. And here we didn't have that. Certainly we didn't have that at the time the public defender was arguing this. Again, it was just a looks like me, charged with me in other cases. That didn't say or make any connection to this particular burglary at all. The defendant wants this court to adopt a standard that's a scintilla. That just saying, getting on the stand and saying someone else did it and it's him is enough. But Elmar specifically says that is not the standard. We need something more than someone just pointing a finger. We need some physical evidence. We need something that connects this alternate suspect to this particular crime, and we don't have that here, even with the addition of the witnesses that the defendant tried to throw out at trial. And if the court has no further questions on the alternate suspect, I will turn to the alibi. I think there are some questions for me on that one. The first question, I think, probably deals with my concession regarding Hampton 2. And I stand by that concession. I don't read Hampton 2 as changing the sentence in Hampton 1 that says a defendant's own testimony is treated differently.
So you agree it was error then for the court to say you can't say where you were?
I do. And certainly this court is free to reject my concession if it reads Hampton 2 differently. I don't think it does. And the reason I think that is because the cases upon which Hampton 1 is built specifically exclude a defendant's testimony. More importantly, the cases that applied Hampton 1 afterwards, I think Banks is the one I cited in my brief, say that's what it says. Defendant's own testimony is treated differently.
Okay, then my next question, which you were probably going to get to, is this constitutional harmless error or regular harmless error?
I think it's regular harmless error for the reasons that this court expressed. One, it's a trial error. Two, it didn't eviscerate his defense entirely. He was still able to testify that he was not there. He was not even in the county at the time. So the jury still heard what was essentially an alibi defense, just not I was in a specific place.
Is that the same thing, though? I mean, saying I wasn't there seems different to me than saying I wasn't there and I was somewhere else with specific details. And I'm not sure. Are you aware of any cases that like define alibi, I guess?
None that I think would directly go to this point off the top of my head, Your Honor. But I do think, while it's certainly different to say I was in Blackhawk versus I was somewhere else, I think I was somewhere else gets you close enough. Really what it is telling the jury is it can't have been me. I wasn't in the county at the time, is what he told them. That he could have said I was in Blackhawk would not have changed the analysis for the jury here for one very critical reason. He could not provide any support for that. He could not, even if he had anything that existed, say, look, there's this videotape of me at one of the casinos in Blackhawk, or someone was with me. None of that evidence would have been permitted.
But
as
I mean, might not the jury have weighed his testimony differently if he was able to give the details that they were asking for?
In terms of the jury questions that they were at?
Correct.
I don't think it would have changed here because, again, what the jury was really looking for is, in fact, I think one of the jury questions went to the Blackhawk testimony that was later not stipulated out, struck. Yes, was struck out. But what the jury was looking for wasn't details. It was looking for, really, you're saying you were somewhere else. What support do you have for that? And the answer here was none. And it had to be none.
A timeline. I mean, his own testimony could have supplied a timeline.
Couldn't his support have been that he's really convincing on the stand? I mean, this is, and the detail, look at the, I mean, talk about contemporaneous events. Look at Stormy Daniels' testimony the other day, where she gave excruciating detail, and the point that the prosecution made was all of these details, you know, the color of his shaving kit or whatever, lend credibility to that account. And maybe he's able to say, well, I was selling, you know, this kind of marijuana instead of that kind of marijuana, and I was doing it in front of the Lodge Casino that has terrible commercials on the radio that I can't stand. But regardless, those details that seem might lend credibility to his account that he might not need, you know, videotape or whatever because he's so convincing, right?
Yes, I think I could concede that point, but I don't think it changes the harmlessness analysis here, which is the jury still had heard the critical component, which is I wasn't there. I mean, he wasn't stopped from saying I was somewhere else. He wasn't stopped from saying I wasn't even in the county.
Well, counsel, just to push back a little bit on your standard of review argument, I mean, Krutzinger doesn't require that it be as virtually, or that he not be allowed any opportunity. It is, I think the language of Krutzinger is denied virtually as only means of effectively presenting a defense. So, I mean, by taking away the Blackhawk component, isn't he being effectively denied virtually the only means of presenting that defense? I mean, it just seems utterly unsupported when you're not able to provide any, details about where you were. So kind of frame it in Krutzinger for me. I mean, how is he not effectively denied the alibi defense?
I would say, simply put, the jury asked questions about it. So they were considering his defense. I mean, I think I would kind of turn issue 3 on its head here. The defense counsel tries to paint that question, that lack of evidence question, as demonstrating harm and an inappropriate response. I think what that question was actually showing is the jury was asking itself, what support is there for this? And there wasn't any, and there couldn't be any. I'm not sure if I'm getting to the court's question here, but I don't think Krutzinger is concerned with the court issuing a ruling that completely prevents the defendant from presenting any component of his defense or having any defense at all. That isn't what happened here. The defendant was left with something, even if it was less than what we would have preferred.
If we disagree with you and decide to apply constitutional harmless error, what's your position? Do you think that we still affirm? It does seem that this could turn on the right standard of review, right? Because of just the different analysis. So what's your position? I know your brief argues for just regular harmless error. What if we choose to apply constitutional harmless error?
I think the result's the same. And for the reasons I've already expressed, plus looking at the strength of the evidence here, there was significant DNA evidence. In fact, I think the DNA analyst that testified at trial describes it as 96% of the mix found on this mask was to the major contributor, which was the defendant. The other 4% was the minor contributor. That caught my attention when I was rereading it this morning. It is almost damning DNA evidence that anything else that was found on that mask was perhaps touch or transfer, not from someone wearing it or physically taking it with them.
On the flip side of that, though, is the lack of identification. I mean, my recollection from the record is that the victim there was an argument about whether the victim should be able to try to identify the defendant when he was on the stand for the first time, and that he couldn't do it.
That's right.
Is that right?
Yes.
And so, I mean, that's tough for me to say that he has an opportunity. The prosecution asks a question they don't know the answer to, and then he's unable to, and the jury's got to look at that and say, wow, he can't even identify the defendant, and without an eyewitness identification, and with a little bit of wiggle room in the DNA question, that's hard for me to get to constitutional harmless error.
Well, I think that's where the 404B and the MO comes into play here. And I think there was significant evidence that substantial portions of how this crime occurred, how it was facilitated, were similar to and readily identifiable to the way that the defendant had committed previous burglaries.
With his crime partner, though, right? I mean, didn't they both use the same?
At least one of them. His crime partner wasn't involved in all of them.
Okay.
I want to make sure I hit everything on the alibi that I was hoping to hit. If the court has no further questions on the alibi, I think I did hit everything I wanted to say. I am willing to entertain questions on any of the issues here. I know there are several that have concerning elements.
Well, counsel, I'll ask the same question I asked to Mr. Goodner. If we choose to reverse on the alibi issue, do we need to reach any of the other issues raised in the opening brief?
I think you still would need to reach the alternate suspect issue, in part because of the timing. That is the only one I think is a close call. The rest of them, I would agree with defense counsel. It is hard to predict that they would play out the exact same way on retrial.
Doesn't the alternate suspect issue, I mean, he would have another opportunity to offer to tell the court, hey, I'm going to offer this alternate suspect defense, and presumably his timing would be better this time, right? It seems to me the record may not be the same in front of the court if it's called on to make an alternate suspect finding before trial.
I would agree that's possible, yes.
Okay.
If the court has no further questions, I would ask you to affirm.
And we'll take rebuttal.
Thank you very much. I just want to push back on the idea that the jury heard the critical, and I know we've talked about it a little bit. I don't believe the jury heard the critical component of his alibi claim. They heard a base alibi claim, hey, I have an alibi, and then they weren't allowed to have any details about it, even though they asked questions about it, and then he wasn't allowed to answer those questions. And going to those questions, I don't believe the questions show that he was really given a chance at the defense because he wasn't allowed to answer the questions. They weren't asked, and the jury left to go to the deliberation room with these unanswered questions in their mind that he could have answered when we have these other identity problems that are already going on in the case. And I think that explains how we get to number 3, where the jury, issue 3, where the jury is saying, hey, and here's the quote that they said, can we consider the lack of alibi for Mr. Taylor? I think it shows that the jury is upset that he has made this base claim, that he hasn't backed it up, and they're holding it against him. And what they don't know, and what's so unfair about that, is that he's basically being punished because of the court's improper ruling not letting him provide that information. As far as the DNA, it's really not overwhelming evidence. 96%, if you just look at the numbers, sure, 96% is a big number, but the government in their opening statement says, hey, the burglar carried the mask, and that was everybody's position all throughout. The burglar never wore the mask. Well, wearing the mask, breathing in the mask, having it come into mouth contact, that leaves a major profile behind. The DNA analyst testified to this on the stand. Carrying the mask leaves touch DNA behind. That's the minor profile. And I point out Rios Vargas, I know it was an alt suspect case, not an alibi case, but Rios Vargas applied a constitutional standard of reversal to an alternate suspect exclusion. There was a single source DNA match without the equivocality that we have. They still said it wasn't harmless. And we've got a lot more problems with identity in this case. And in terms of timing, there's nothing inappropriate about the timing here. This is just how this happened to go in this particular case. And honestly, it's sort of explanatory of a trial court's discretion, the way things went. Mr. Taylor requested an endorsed alternate suspect almost 8 months before trial. He requested a hearing to address related issues. We didn't have the guidance of Dye then. But still, we're 8 months out and he's requesting the hearing. The court sets the hearing for 41 days before trial, but there's a writ failure due to COVID. That's not my client's fault. He can't attend that hearing. The actual hearing happens 27 days before trial, and that's when he discharges counsel. It wasn't 10 days before trial. It was 27 days before trial. The next 2 hearings, the court invites counsel back to the next 2 hearings and says on the record, hey, I'm hoping he'll take you guys back as counsel. My client doesn't want them back as counsel, but he's not allowed the next 2 hearings to really have a free hand in advocating for himself because his lawyers that he's fired are still being invited back. It's 11 days before trial at a hearing on 10/14 that the court enters an order denying alternate suspect. And they're in court, and the court says, hey, Mr. Taylor, by the way, I just denied alt suspect. And Mr. Taylor says, okay, well, I had a bunch of stuff I'd like to say that I wasn't allowed to say it the last time because I was represented by counsel. Would you let me have an opportunity to reconsider it? And the court says, yeah, you can do that next time. Well, next time does happen to be shortly before trial. It's the readiness conference, but that's because of how things went, when he had requested a hearing to resolve all this stuff almost 8 months before trial. And both Dye, I think paragraph 64, if I'm recalling correctly, and Dye says that a trial court can extend the 35-day deadline that we didn't know about then because Dye didn't exist when this case was litigated. But if you apply it, back, Dye says, I think paragraph 64, you can extend the time for good cause. Well, good cause exists when you have a newly pro se defendant and the government's not objecting. They did object to the timing of the witness endorsements. They did not object to the timing of the offers of proof. They did not object to the court's decision to reconsider. And given that it's a motion to reconsider, you may also review it under the law of the case, but the analysis is really the same. Does he have good cause or changed circumstances? Well, yeah, he does. He just went pro se. And is there prejudice on the other side? Well, we know there's not. The government didn't even object. And we know they knew how to object because, 1, they're represented by counsel. 2, they objected to the timing of the witness endorsements. It shows that they knew how to, make Rule 35 objections, and they didn't choose to make that objection with respect to the timing of the proffers. That's all I have, unless there's questions.
Thank you.
Thank you.
Thank you both for your fine arguments. The case is deemed submitted, and you may expect a written decision in due course. With that, our docket for today is completed, and the bailiff may now announce a recess.